Bam! Good morning. This is Attorney Vince Davis. These are Monday morning office hours, and this is where I answer a question that has been emailed or posted. Um, I'm an attorney here in California. I've been practicing about 31 years, and I'm an expert in CPS cases. People hire me to get their children back or get the child back to their families, and that's what I go to do. This morning I'm on my way to Los Angeles County Court in Monterey Park to represent a mother whose child was detained. So the question this morning is from a relative, and the relative wants to know how they can get the child placed with them. Any relative or any nephrim that's a non-related extended family member has to make an official request in writing to the social worker that they want the child placed there. Now, what I'm finding in a lot of cases is social workers are relying on something called the ASFA process in order to place a child in a relative or nephrim's custody. And that could take weeks, couple months, 3 months. It takes a long time. Now there are two ways that a child can be placed with a relative or nephrim. Number one, emergency placement. That emergency placement has to happen by way of either one of two things, the social worker or the judge. Now remember, social workers, when they make decisions on cases, they're not the final arbiter of what's going to happen. So if a social worker, if you ask for placement, emergency placement, and the social worker denies it, what do you have to do? You have to go down to the courthouse. You have to get in front of the judge. There are certain papers and documents that you have to file, and you have to request a hearing to get the child placed with you. Most judges, from my experience, will place the child with a relative or with a nephrim under, emergency circumstances. Now, after you get the child under an emergency placement, you must then follow the ASFA requirements and apply, etc., to be approved officially. But before that happens, you get to keep the child. Now, I'm going to tell you a story that happened up in Northern California. Mom was in jail. Father wanted the custody of the child, but they had some allegations against the father, and so I wanted the child placed with one of the one of the father's relatives. And my client wanted that also. I didn't get that child placed with a relative until the middle of the trial. I mean, it was weeks down the road from when I first appeared. And I got the sense that in this particular counties, and sometimes in some of these Northern California counties, that they don't really place children with relatives until after the disposition hearing. Now, you don't want to wait until after the disposition hearing because then there comes up arguments, well, the relative doesn't know the child that well, and, the child is forming a bond or has formed a bond with the foster parent. A bond being a physical, emotional, or psychological connection. So go to court early if the social worker tells you no. Now, how do you get in court if you're a relative to get the child placed with you? You file a 388 petition. You file the de facto motion under Charles S. You don't have to have taken care of the child. A lot of people think that, but it's not accurate. Google in Ray Charles S. and read that case. So you want to file these papers and get in front of the judge as soon as possible. When it became clear to the judge, when it became crystal clear to the judge that the social workers didn't want to place with any relative, and I kept, harping on what the law was, what the law was, what the law was. By the way, the law is Welfare and Institutions Code, Section 309. Please Google it and review it. He placed the child with the social worker, excuse me, over the social worker's objection with a relative. And I had given several relatives names, right? And they picked the one uh, second farthest from the courthouse in another county. You know, there was a relative or two inside the county, but they put the squash or, they kibosh on that, on those relatives. I don't know if they were doing that because they were serious or they were trying to make it hard for my client to visit, to kind of make him pay for insisting that the child be with a relative. So the second way is the ASPA process, the RFA process, where the relative has to go and apply and be checked out, and they have to look under every rug and carpet and every cabinet of the house, and it takes a while for to get that approval. So you want to get the emergency placement if you can right up front. Now, um, if you have a problem with the social worker, talk to a lawyer so that you can find out how to get emergency placement. Or if you're a parent and you want your child out of foster care, which gives you more leverage if the child is out of foster care. It's like the difference between, hey, you're in jail on a crime and then you bail out. When you get your child into a friendly relative or foster parent, the leverage in the case kind of swings back to your advantage. That's just my humble opinion. Now, you're probably watching this video because you or someone you know has a CPS case. Check out my website, fightchildprotectiveservices.com, fightchildprotectiveservices.com for resources. Look at YouTube, Vincent Davis. Um, you can put my name in the search bar and you can look at some of my resource videos. And listen to the radio show, The Secret: How to Fight CPS and Win, every Saturday night from 7 to 9 p.m. on KABC 790 AM talk radio in the Southern California area. Also streamed at KABC.com, and also streamed here at this page at Facebook Live. All right. Look, I'll have a good day, and I'll see you this evening for the evening office hours at 8:30 p.m.